Thakkar, Bhupendra Thakkar sir and Advocate K.H. Katharia sir. Thank you, sir. I would now request CM Maulik Patel sir to welcome Advocate Manish sir with a memento. Thank you, sir. Sir is presently practicing as an advocate before the Gujarat High Court Income Tax Appellate Tribunal, Commissioner of Income Tax Appeals and Supreme Court of India in the field of direct taxation and has been past president of IT Bar Association, Ahmedabad. Sir, I request you to kindly come forward and address the gathering. Okay. Let us welcome sir with a big round of applause, everybody.
The foray that is brings into the forefront lot many old case law and the basics which we call the rudiments of law. The college if in case so many of you who are law graduates would have done jurisprudence of law. That is where we had learned something called principles of natural justice. Now why did this become very, very important? Samajwani jarur hai. It became very, very important because now you are in no contact with the officer. It is a contactless sport, as you say. And that is where you need to know and recollect your old principles, which are known as principles of natural justice. Because all litigation today in the High Court, as well as when it will come down in the, because CIT appeals are on a slumber. There is nothing like any litigation as far as CIT appeals is concerned, but that gives you an opportunity to sharpen your weapons before they start. But before I go, I'll be missing out on my duties because I was there for the inauguration, and what a wonderfully organized inauguration as well as a seminar. So I congratulate the entire team of AGFTC as well as IT Bar Association, who's got a very young and dynamic president who's having the experience right in Hiren Bhai over there, and obviously Dinesh uncle, whom obviously lovingly I have to refer to as uncle because he is the senior and was my father's friend. Mitesh Bhai, who has come from Surat, and lot many seniors whom I'm seeing over here, along with a mix of gathering. Ladies and gentlemen, please enjoy it. I'm not going to show you anything on screen so that you can relax and note down a little case law that you want to note down. Otherwise it becomes too strenuous, doesn't it? I'm still the old book who likes to refer to pages and papers, write down notes, tick mark things. So kindly pardon me if you are the new generation, right? Though in the new generation, I'm still the old one. That's how. So friends, okay, I'll also be missing two doctors. It was wonderful to know that we've got two guys who've got PhDs over here. A big round of applause. I'll have to spend some time with them to know exactly how you go about things. Now, it's wonderful. Please accept my congratulations. Friends, koi bhi topic discuss karta pehla, if there is some history to that, we must always make it a point to refer to that history. Principles of natural justice also has a deep-rooted history. The historical background is in this wise, that undoubtedly our Vedas had the concept of principles of natural justice. But as far as case law is concerned, and the discussions and papers which were threadbare discussed, it started all the way in UK. So it's an import from the banks of River Thames to the river of Ganga. So the entire concept, and we were always ruled by the British, and that is the reason the colonial concept of principles of natural, though with great respect, they did not follow it in India. But we do have a background which comes from there. બે એક ઇન્સિડન્ટ અને એક સ્ટોરી I will narrate to you so that it gets. This reminds me of a wonderful teacher that we had, a Spaniard by the name Father Morondo in Xavier's. He used to teach the entire Mughal and Rajput history by examples. And that is what, got it ingrained in us, and it was so easy and lucid to understand what the history meant. So I have followed a little bit of that as far as principles of natural justice is concerned. One incident, which is a very, very telling incident on a few principles, the rules of natural justice. One is a very strong concept by the name rule of bias. Now, the most interesting incident is, which happened in the US Supreme Court, and a bench of 9 judges was sitting in the Supreme Court, and one lady judge, Justice Connors, requested that I must be excused from the bench. She was a very senior lady, like we had in Justice Gokani in the morning, and a very respected lady as well, and her being on the bench would have helped in ultimately solving that company's issue. She said, no, I cannot be sitting because my husband is a shareholder in that company. They said, ma'am, we don't question your objectivities or your independence as far as this is concerned. So kindly continue. She said, no. You must always be seen as not being involved in unconscious bias as well. Not only conscious bias, but unconscious bias also. I also know I'll be objective, but the people who will be witnessing it, they will not be sure about it. And that is the reason, this is the level at which a judge has to function. And you could translate it to one of the case laws that I'll be discussing. There'll be 2 case laws that I'll be discussing where there's a conflict of this kind of a bias. Second, and one of the most interesting stories on the principles of natural justice, on Audi Alteram Partem. Audi Alteram Partem, please, mehrbani karine, ingrain it in your memory as far as faceless assessment is concerned. Karan ke aa cheez is going to be repetitively coming to use, and that is the reason we have to be very, very clear as to what are the scopes and heights of Audi Alteram Partem. So the incident in Greek mythology is in this wise. There's a very interesting character by the name Prometheus. Now, who was Prometheus? Prometheus was a trickster. એટલે તોફાની કેરેક્ટર. આપણા માઇથોલોજીમાં નારદ હતા. ત્યાં Prometheus હતો. Now, Prometheus was also well known for bringing the concept of fire to mankind. He gave fire to mankind and taught them how to use it. He had stolen that fire from the gods of Olympus. But there were courts which were going on. So Zeus, who was the major god, punished him and got him tied to the rocks and ordered his eagles, in those times there were a weird way of punishing, to eat this guy's liver. આટલું બધું ટ્રેચરસ કરવાની કેમ જરૂર હતી? This was necessary because Prometheus was immortal. So one day they would eat his liver and the next day he would become all right. This was the punishment which was meted out to him for giving fire to mankind. Imagine what a gift he gave to mankind, but he was punished for that. So when Zeus was one day sitting in his court, a shining character came about. And Zeus asked that, who are you? The figure said that I am truth and justice. And he said, what brings you to my court? That I have come to know that you have convicted Prometheus without giving him a hearing. And you have punished him without hearing his story. And that is the reason, though you are one of the major gods, you will be dethroned for one day. So that is the level at which principles of natural justice in the Greek mythology has also been put. A Greek god was dethroned from his throne for one day for not following the principles of natural justice, of giving a hearing to the other side before pronouncing him guilty or not. You have to hear the other side. Now, why did I narrate this? To hear the other side. So many times in the chamber when we have been filing writ petitions against this is we were not given show cause notice. I was not given the draft assessment order like previously before the amendment. The draft assessment order and the show cause notice did not come together. All this would be falling under the canopy of odi alteram partem. Principles of natural justice have been violated, and that is the reason the order cannot stand. Now, why does this become important? Why these challenges become important? Kindly keep it in mind that an assessment order which would be passed without you being heard or without your submissions being taken into consideration, which will be reflected in the order by the dealing of those submissions in the order, if it is not done, you will be the greatest sufferers in this wise that you will be required to go in an appeal against a faceless assessment order, because you will not be in a position to state that I want to further submit this thing. Supposing a show cause notice is not given. If would have been given, you would have submitted certain things. That would amount to filing additional evidence before the CIT appeals. Second, 20%, મહેરબાની કરીને હવે 15 થઈ ગયા હશે, 15 થઈ ગયા છે? How much do you have to pay before going to the CIT appeals on the 20%? So 20% is what you would be required to pay because of the fault of the officer. Thirdly, you will have to convince them, all in faceless once again, that it was not my fault. It was the fault of the officer. And all this in writing. That is the reason it becomes very, very important to put your best foot forward in the first hearing, that is before the assessing officer. And if not done, there is no response from the assessing officer, which has been the case in most of the cases that have come to us, because I believe, frankly speaking, I agree with Justice Gokani that this is a very laudable objective of coming to a faceless assessment. But આપણે બધા જાણીએ છીએ કે why it has not been very, very successful, that it should be. There is an undercurrent that a lot of effort is being put in to see that it does not succeed. That is the reason we have to put in the effort to see that it succeeds. Because there will be an entire generational change which is taking place, and the younger generation or our future generations are going to benefit from this concept in a big, big way. So it becomes our duty to see to it that this does not fail. So keeping this in mind as to what is the object behind your challenging or being very, very careful as far as these concepts of odi alteram partem have been considered or not, is something that you would be required to check very, very regularly. Now, why does this conflict take place? We are dealing with an invisible executive now. Now, what is the role of the executive? The role of the executive, if I put it very plainly, is to collect tax. So their focus is on collecting taxes. So they will not go by the fact that, okay, I have infringed this rule technically over here or technically over there. They will say that my ultimate aim is a very laudable object to collect taxes for the nation. So please don't tell me that I have in the process missed out on following this procedure or that procedure. Vis-a-vis the judiciary. The judiciary has a very clear concept that the end does not justify the means. And what do I mean by that? The end does not justify the means, meaning thereby the end might be a very, very laudable process in the sense of collection of tax. But if the means are not proper, let's take an example of 148-263. Show cause notice is given, 148 previous regime, reasons were to be recorded here, information is to be there. If it is not there, if it is not proper, if it is not in the proper format, then these notices will be failing before the judiciary. But as far as the executive is concerned, I'm sure some of the seniors will agree with me when they used to have physical hearing. 148 નું પહેલું જ આર્ગ્યુમેન્ટ લો એટલે કે આને છોડી દો ને, ટેકનિકાલિટીની વાત કેમ કરો છો? Now, it was that easy for the executive to tell us that come to the merits of the thing. God forbid, but I don't want to talk about merits. Talk about the technicalities first. You've entered into the merits because of the technicality. They were never ready to do that. Unfortunately, sometimes in the higher forums also we have to remind them that that's not the way to go about it. First the technicality and then the merits. Most of the times they are right. We would be talking about technicalities because the merits might be a little weak. That's what. But the fact is that the judiciary, a judicial mind, will always want things to be done in a proper fashion, and that is where the notices and all that will be important. See, in the present regime, this kind of difficulty of you facing the officer where he is going to tell you that, come on, give up your technical argument on 148 or 263 is not going to happen. But it opens out a window for you to put your best foot forward and give your best submission as far as this technicalities is concerned before the officer, because he is bound to deal with it. એટલે ખાસ કરીને આ ચીજની ધ્યાન રાખજો કે now your technical arguments also have to be rock solid, because એ જ તમને કદાચ ફ્યુચરમાં કામ લાગશે. And I've been telling this in all my talks and seminars. You are the guys who give birth to that baby which is the assessment order. We are not there. The difficulties which we face before the tribunal and the high court, we can come and share with you in some seminar like this. But sometimes it is too late. So be careful. Ek audi alteram partem, before I go to certain interesting cases, what is it that you have to have as a checklist in every show cause notice? First of all, you should have a right of notice. હવે નોટિસમાં શું ચેક કરવાનું છે? The time, place and nature of hearing should be very clear in the notice. Legal authorities under which the hearing is to be held should be very, very clear as to who, against whom. Now the most important thing, the statement of charges against you should be very clear in the show cause notice, because it is to that you are going to respond. So many times it has happened that the charge is A, and you would get now in the show cause notice later on absolutely a different concept by the name B. So if you are not in a position to correlate, supposing the show cause notice is A, and on a different topic altogether the entire assessment order is passed, that assessment order cannot stand. Why? Because you were never given a show cause notice on that. So these are the different things that you will now require to do, which we are not doing previously, because it is all faceless. Previously you could have gone to the officer and say, sir, આ શું છે? He would say, okay, chalo, come on, file a 154 and get things done. You don't even know where your 154 or your next assessment is going to go now. So that is what, these are the things that you have to take care. Now friends, 2 or 3 concepts that are required to be kept in mind. First and foremost, મને ઘણીવાર while we are dealing with a particular subject and somebody has come with an issue, at times I am asked by the advisor, sir, for principles of natural justice ની તમે વાત કરો છો, but it is nowhere specified in the section. So a question arises to the practicing class that does it need to be clarified in the section? That yes, if this is not done, then the principles of natural justice would come into play. That kind of an issue has been arising before the courts, and the courts have now made it very, very clear that principles of natural justice have to be read into the section. They are not required to be specified. It's an obvious thing that you have to go by it. It is not something which is required to be laid down in the statute. Previously, there was a very clear demarcation that principles of natural justice will not be applicable to administrative orders. It will be applicable only to judicial orders, that is quasi-judicial orders. Now what do I mean by administrative orders? Say for example, your case is being transferred from one place to another. You are not required to be given a hearing. That it is an administrative thing, we are just transferring it from one place to another, no hearing is required. That is an administrative decision that we have taken. The court said that no, we have obliterated the line. There is no demarcating line between a quasi-judicial order and an administrative order. Hearing has to be given. So that is a very, very important thing which should be kept in mind. For that you can refer to 287 ITR, page 91, Supreme Court, Rajesh Kumar, where they said that now the concept of an administrative order being treated differently than a quasi judicial order is to be given a go by, you have to deal with it in the same way. They have taken this concept even further. Say for example, additional evidence is given. Rule 46A ની વાત કરીએ આપણે. There also in favor of the department they have said that though it might be very obvious that the additional evidence that you are giving is not required to be sent back to the department for their replies. Let us decide it here and now. The court said that that cannot be done. Principles of natural justice will be equally applicable in favor of the department as well. So in that kind of a situation, Kerala High Court in 234 Taxman 802 stated that in the rules also, principles of natural justice will be required to be read. Now, friends, a very, very interesting decision as far as bias is concerned. And હું આ ડિસ્કસ એટલે કરી રહ્યો છું કારણ કે there will be a 2 or 3 situations where this concept will be coming into play in the fore. 2 case laws I'll be discussing, conflicting case laws, both of the Supreme Court. One is under the general law and one is specifically under the income tax. What was the one in the general law? It is AIR 1970, Supreme Court 150, A.K. Kariyappa versus Union of India. Now, what was the situation? અહીંયા સિચ્યુએશન એવી હતી કે A.K. Kariyappa was the acting chief conservator of forest. He was in the acting, meaning thereby he was not fixed as yet. And he was also a member of the selection committee which was going to choose the conservator of forest. But along with that, he was also a candidate for that choice. Now imagine, he is the acting chief conservator of forest. He is on the committee for selecting the new member as the conservator of forest, and he was also a candidate. But he was fair enough to state that when the selection of my selection discussion comes about, I will leave the room. But will participate in the discussion when supposing you are to be selected or he is to be selected. Though I am an interested party, but I will be party to the discussion of whether what are your negatives or your positives. This was challenged before the Supreme Court. The Supreme Court held that there was definitely a conflict between his own interest and the duty cast on him, which could prevent him from being impartial. We don't know whether he was impartial or not, whether he was partial or not. We are not very sure. But there is definitely a conflict of duty, and we are not sure whether that partiality or impartiality came into being or not. And that's where the Supreme Court upturned the decision and cancelled the entire process. So this is where a personal bias concept came in. With versus this, an issue arose in the income tax foray. 260 ITR page 1, Supreme Court in Union of India versus Vipin Kumar Jain, the SSC challenged that, sir, there is a bias in the order, the assessment order, because the search party was being headed by an individual who is now acting as the assessing officer, and that is the reason there is a concept of official bias which is coming into play. The Supreme Court stated a very interesting thing. Now, according to me, I believe the general law on principles of natural justice were given a go-by in this decision, but I do not know whether anything further has been done in the form of a review or not. It says, if the SSC is able to establish, there in that case said that it is to be presumed. So, proof of bias versus likelihood of bias became a conflict. Here they said if the SSC is able to establish that the SSC in fact was biased, in the sense that he was involved or interested in personal capacity in the outcome of the assessment or procedure for assessment, no doubt it would be a good ground for setting aside the assessment. Now pausing here for a moment. That man is a party to the search. All of us are aware, being practicing on the income tax side, the kind of work that goes behind before a search takes place. So he would have been involved in all gathering of those material as well. He must have researched on it. He must have put in a report which goes to the higher ups, the CITs, the entire committee. They sanction that, okay, we are satisfied that you require to go ahead with the search. and then he acts as an assessing officer who's otherwise supposed to be an independent agency, and we are supposed to tell them that whatever has been done in the search is not in order. I believe the Supreme Court has missed out on the main plank, that more than the Kariyappa's case, this would have been an A for surety case where concept of personal official bias would have come in. Let me give you one or two examples of this, which happen in the income tax regime. Say, for example, an assessment order is passed and it is challenged before the CIT appeals, and that very assessing officer becomes the CIT appeals. Concept of official bias. 2. CIT appeal passes an order and is posted in the tribunal as a DR, that's where it is challenged and he is appearing. Concept of official bias. He might have passed it in favor or against, but bias remains because he is wedded to that order. He should not be allowed. Interestingly, what we face in the High Court sometimes, matters are referred to a larger bench, or it happens in the tribunal also, matters referred to a special bench. Be in that special bench or in the High Court, should you be having the very same judges or members who have referred it to a special bench or to a larger bench? According to me, in fitness of things, it should not be the case. Because they are already interested parties who have referred it. But sometimes it does happen, and according to me, purely if I go from the angle of bias, it is not proper and that should not be permitted. Now, these are not for general knowledge that I am sharing it with you. Be gutsy enough to take up this kind of issues when they creep up in some very, very important litigation. Keep these things in mind. You will be able to knock out the order and the demand coming to zero, and a fresh hearing will be given. Friends, there are certain decisions which will be very, very helpful and which are old decisions for the purposes of kind of issues that we are facing in the faceless assessment. I was just talking to someone about day before yesterday, and I thought this would not be happening still, but seems to be a very recurring issue. કે સર 3 દિવસનો ટાઈમ આપે છે, આપણે એડજોર્નમેન્ટ માંગીએ એટલે ફર્ધર 3 દિવસનો ટાઈમ આપે છે. Frankly speaking, if your facts are such that they have given you a notice with a limited time frame, which you are in a position to demonstrate that this time is not enough, and you have asked for an adjournment and further unreasonable time has been given, that assessment order becomes a vulnerable order, because one of the principles is that sufficient time must be given for you to deal with it. A direct case law on this is 251 ITR 197, where, what were the facts? 2-3 line માં કહી દઉં. 37I, presumptive taxation માટે you were required to file forms કે ભાઈ whatever is the price that I am paying for this property is in order. There is no conflict as far as 15% variation જેવું નહીં મળે. This was filed, say for example, from today 2 months before. Anil bhai, they give a notice just about a week before the limitation time period expiring, that we have some problems with this. The SSC said that you have not given me enough time. How would I respond to it within the 3 days that you are granting to me? Then to an order was passed. This was challenged in the High Court, and the High Court said that now it was challenged in the Supreme Court. It went to the Supreme Court. The Supreme Court said that this is absolutely an unreasonable and the most inadequate time that you will be giving for the purpose of this. Now, ઘણા લોકો આ 2 કે 3 દિવસના કોન્સેપ્ટમાં પ્લીઝ અટકી નહીં જતા. એ 2 કે 3 દિવસ કદાચ 1 કે 2 ઇશ્યુ હોય તો એની વાત છે. So supposing you are dealing with a company's matter where there are 15 issues and you are given, say for example, 10 days, that 10 days also can be unreasonable for you to be dealing with that. If you have taken care of filing things in advance, that care has to be taken by the officer also for giving you ample time for you to respond. So this may kindly be kept in mind. Personal hearing is also an important aspect of principles of Nyaya, and that is the reason video conferencing has been made compulsory now. But video conferencing નો એક બહુ ગ્લેરિંગ એક્ઝામ્પલ આપણે થોડો વખતમાં ડિસ્કસ કરીએ છીએ હમણાં કે વિડીયો કોન્ફરન્સિંગ કઈ રીતે આપવામાં આવે છે. Though personally speaking, my experience of only one video conferencing was that, though I don't appear at the assessing officer's level, but they wanted me to appear for only one issue out of the 10 issues. and the stake was running into about 45 crores or so. And the only mistake was an entry mistake. But the stake had become so heavy that it was weighing on the client, it was weighing on the chartered accountant, and it was weighing on the officer as well. So they had asked for a video conferencing. My personal experience was a good experience. I do not know about, some of you must be having a good experience, some of you might be having a bad experience. So we'll be discussing the bad one, but my good experience is that on a hearing, which was a proper good hearing, we were facing the officer, I could see him, we could interact, and those 45 crores was dropped. So it was a wonderful experience as far as I am concerned. But then we are not here to discuss the good experiences. We are here to discuss the bad experiences. Yeah? So, now, tactically बात करिए, तो when I used to appear before the CIT appeals, I used to always have this very clear concept that I will take 2 hearings, I will try to know what is going on in the mind of the CIT appeals, and एना પછી જ written submission આપીશ. Some people used to, the CIT used to have a written submission नहीं लेके आए. मैं कोई ऐसा कहीं लिखा नहीं है मुझे written submission देना है, शायद मैं decide करूँ नहीं देना है. Why did I decide to do that? It is very important to know what is the mind and how he is thinking. Because in the 2 hearings, I will try my level best to get exactly the line which he is wanting to toe. Then I would incorporate that in my written submission so that there are no boxes which are not ticked. I would suggest the very same thing. You have a right of video conferencing now. The moment you ask for it, they will have to grant it to you. Take that video conferencing. I do not know what are the technicalities. Take that, if possible, take that video conferencing beforehand, not in the end. On an issue which is ticklish, where you need to put your, all your weapons at stake, take it beforehand. Have that video conferencing and then find your written submissions. So you would know exactly what is going on in the mind of the officer and you will be able to address it. This is very, very important as a strategy. If you can follow it, then you will get some good results. Precisely. Know thy judge. That is what it is. Say, for example, I have some colleagues in the office who tell me that sometimes this faceless assessment turns out to be a boon. I said, why do you say that? What is your experience? He says, sir, Gujarat High Court na decisions છે ને થોડા ઢીલા ઢાલા હતા. They were talking both ways. Fortunately, my matter went to the Rajasthan officer and there was a crisp decision in my favor. Favor my you, sir. So these are the advantages sometimes that you get, But it can work the other way around also, because I'm going to discuss with you also something whereby you might have to remind an officer that, sir, you are dealing with a matter which is from the Gujarat High Court jurisdiction or an Ahmedabad tribunal jurisdiction which will be binding on you. Because his entire psyche, suppose he has worked in a particular region for more than a few years, he is going to be aware about the case law in that region only. And that is the reason your additions are also going to be accordingly. I am noticing that as far as 14A is concerned. Because in certain jurisdictions, 14A has a very peculiar way of looking at things. While Gujarat has made 14A very, very clear, considering Maxop as well. Amok states ma, still the devil of 14A is alive, and you will notice that, I am sure this has come from that state, because you can find out the line that he has told. That is where I would suggest, before the officer also put in all your case law which is in your favor. Please, for God's sake, don't go by the old formula, thodu rewa devanu, pachi apisu. Nahi. Please don't do that. Because, God forbid, 2 things might happen. If you are challenging it before the CIT bills, you will still be there. But God forbid, there is an issue where we would be required to go to the court. The court would say, you have not put in anything. So don't blame the officer. Now, you will have to strategically change as far as thinking is concerned, how to go about in the faceless regime. Because you can really get hurt. Because here, apni face value and any face value nathi chalwani. You will not be able to enter somebody's chamber and tell him that, look here, sir, this is the drastic injustice that you have managed to do unknowingly. એટલે આપણે એક કપ ચા પી લઈએ. એવું નહીં થઈ શકે. So be very, very careful as far as that is concerned. Right of cross-examination. Now that is going to be a difficult aspect to be doing under the faceless regime. But it will be very, very important because now everything will be traveling faceless further. So keep in mind your right of cross-examination, and a right of cross-examination પણ varied હોય છે. Out and out very clear case where certain statements are taken and he gives you the statement and you ask for cross-examination, એ નથી આપતો. He is bound to give it. બહુ બધા decisions છે. But say for example that there are certain documents which are taken from your premises and your manager is questioned right in front of you and he gives certain statements and you ask for a cross-examination. Would he give it to you? He is your manager, the documents were yours, and you are asking for a cross-examination of the manager. Would he be bound to give it to you? Answer is yes. He is bound to give it to you for the reason that till he is using that statement, he is the witness of the department. The moment you give an affidavit of the manager that this was not correct and this is correct, he to an extent becomes your witness. 75 ITD page 155 is a direct decision on this by the Mumbai tribunal, where if you recollect, Vimal Gandhi Sahab, he was the vice president over here in Ahmedabad, sitting in Bombay, had taken a call. 72 ITD page 155, અને તમારે વધારે મહેનત ના કરવી પડે એટલે 160માં પેજ પર છે. 160, page 160. It says, though witness was examined in presence of the SSE by the assessing officer, if AO does not offer cross-examination to the SSE, prejudice is done to the SSE. So they have gone to this extent. Now friends, one more interesting aspect as far as examination is concerned. Away there are valuation cells. There is valuation for this. There might be an expert at a particular subject who will be giving their report. Supposing if this kind of an expert report is taken into consideration and additions are made, do you have a right of asking for the examination of that expert or challenging that report? The answer is yes. 295 ITR 105. Now what were the facts? The SSE was relying on a report of a research institute. SSE challenged the correctness of that report by filing different petitions and asking for permission on several occasions to cross-examine that expert. They did not give it. The court said that you are bound to give a cross-examination of that expert so that the point of view of the SSE is brought about. He can counter as to in these facts, this kind of report is not in order. And that is where the concept of cross-examination, the vistas of cross-examination will have to be kept in mind, because now you have outfits. Say for example, for land, it will go to a particular outfit where they will be giving their opinion internally. Say for example, valuation of shares, you will have an outfit. It will go to that outfit, they will be giving their report. So all these will be internal reports which will be crisscrossing and decisions will be taken. આ ચીજનું જો ધ્યાન નહીં રાખો તો ફ્યુચરમાં ડિફિકલ્ટી. You must know your rights, you must know when to exercise it. Friends, this is as far as certain things on. How much time do I have? That's it? Okay. Friends, let's do one thing. Let's go to the interesting case laws. Gujarat High Court na je develop thayela છે. First one, I'll be going a little fast now. Gandhi realities. Very, very well-known case, and I think you should be keeping it in mind as far as dealing with show cause notices is concerned. Here, Order was passed without giving a show cause notice or a draft assessment order. But interesting part શું થાય છે? They insist કે અમે આપેલું છે. Now that is where you people will come into play. Okay, we have given it, we have sent it to the portal, and that is the reason our job is done. See how extensively and how intricately writ petitions ma courts go into things. While discussing this matter in the court, they insisted, our stand was, the SSE stand was that show cause notice was not given, draft assessment order was not given. Their stand in the affidavit before the court to the petition was that draft assessment order along with computation sheet is forwarded to the SSE. So completely conflicting facts against each other. The SSE took up a stand that internal correspondence between the departmental authorities also is required to be signed with a DIN. Now if the DIN is not there, then that authorization or that order is of no consequence, not worth the paper it is written on. They were not in a position to file any document where the DIN was there. And that is the reason the court did not take it into consideration. Secondly, screenshots of the portal were given to show that in my portal this is not reflecting at all. So that screenshots also become important. એક જોક યાદ આવે છે પણ પછી I think end માં કહીશું screenshots પરથી. એટલે you must be aware as to what your portal says. I am really surprised how can now in today's time a stand be taken that we have sent it when actually the portal is not reflecting it. There seems to be some conflict between their internal system and the portals at times. But this is happening. As I said, please check whether any document has that DIN or not. That is document identification number. It is a very, very important aspect because it is prescribed in the section itself in 144B that if it is not there, then that document is of no worth. It will not be considered at all. Friends, you will find that in subsection 6 in 144B, where it is stated that for faceless assessment, electronic transfer of documents between internally as well as with the SSE, that DIN is to be stated, and where they find it necessary, they will ask for an electronic signature of the SSE as well. So this is prescribed in the section. Here we got the advantage of it in the High Court when they were not in a position to give documents where there was DIN was specific there, and counter the screenshots of the portal where we were in a position to show that there is nothing in the form of a show cause notice as well as an draft assessment order. So this will become important. The next decision is an interesting decision. Hiren Bhai had asked me to discuss something as far as 68 is concerned. I specifically took up this one because there are two very important features to this thing. Now this is a little different from the normal procedure of show cause notice not being there, draft assessment not being there. Now the draft assessment order has been given up. All this will become necessary as far as show cause notice. But that is where the Gandhi reality comes in. 2022 441 ITR 473 Gujarat. Darshan Enterprises. A very, very interesting issue. The partners brought in capital and there was information, and that is the reason notices were given and additions were prescribed. They gave me a show cause notice that why this addition should not be made. We made a representation running into about 17 pages giving all possible details that were there, that the partners have got this capital and the partners have also agreed that we have brought in this capital. So no difficulty as far as I am concerned. They then too went ahead and gave me a show cause notice that we want to go ahead with the addition for ABC reasons. I replied once again with a further explanation running into around 25 pages with all case law possible. I gave the Gujarat High Court decision also that in the hands of the partners you can do whatever you feel like, it cannot be done in the hands of the partnership, everything. The assessment order was passed exactly on the lines of the draft assessment order. They approached me. I said, you might have to go in a writ petition and we might have to challenge, but it's a little sensitive because show cause notice અપાઈ ગઈ છે, draft assessment order અપાઈ ગયો છે અને પછી assessment order થયો છે. So to convince the court is going to be a little difficult. Now the argument before the court was twofold. One, on technicality, that draft assessment order અને assessment order જો બાજુ બાજુમાં રાખશો તો it's a mirror image. Then what happened to my 22-page submission along with case law? It has not been dealt with only. Case law was mentioned in the assessment order, but no conclusion was drawn. Then how do you deal with this case law? No conclusion. Binding decision of the Gujarat High Court mentioned, no rebuttal. Second, as far as 68 is concerned, very simple argument was, sir, on merits also this is not in order because source of the source is not required to be proved. Now all of us are aware that source of the source is a little dicey situation as far as case law is concerned. But now you have a direct Gujarat High Court decision which says source of the source is not required to be proved. This is the decision. એટલે તમને merits પર બી 68 માં કામ લાગશે as far as this is concerned. The court came to a conclusion that yes, when the draft assessment order as well as the assessment order if seen together, there is no difference. It's virtually a mirror image. So the written submission has not been taken into consideration, have not been dealt with, so this assessment order has to go. And it's said in the process, આ advantages થતા હોય છે when you challenge, that yes, Mr. Shah is right when he says source of the source is not required to be proved for so and so case law. Nemichand of Orissa High Court was extensively quoted. See the advantage that we got. The matter was ultimately obviously sent back, but with a rider that it is to be concluded within this much time, keeping in mind what the High Court has stated. The assessment was dropped. So 3 crores worth of rupees was left alone. So these are the advantages that you get. But you will have to be bold enough in given cases. You don't have to be bold enough in all cases, but in given cases to know exactly what is your right. And then only you will be in a position to exercise that right in the future as to whether you want to challenge it, whether you want to take it up at the CIT appeals level, whatever you want to do. આ એક ડિસિશન આપણે ડિસ્કસ કરી અને we'll call it quits. Video conferencing no supreme example on the negative side. Dr. K.R. Shroff Foundation. I will be reading out certain things because a judgment my incorporate કર્યું છે અને I believe it is, when I read it, it was hilarious કે આ રીતે પણ કોઈ hearing થઈ શકે. The SSC was asking for a video conferencing continuously. It was not being granted. No response. 2-3 મહિનાથી it was asking for. કોઈ response નહીં. The SSC had stated that between 4 p.m. and 6 p.m. ની વચ્ચે કોઈ બી દિવસ અમને વિડિયો કોન્ફરન્સિંગ આપો. We would like to appear and we would like our representative to appear, authorized representative, some lawyer. Here in this case, senior counsel appearing. Not done. One fine day we get a response that, sir, you are right. We were not in a position to respond to you. અમારો વાંક છે. We are willing to give you a video conferencing. Okay, when? Tomorrow. They said, look here, sir. Even if I was appearing, I would have not been in a position to, because I need to prepare to have a video conferencing with you. In this case, there is a counsel appearing and he is obviously having his own busy schedule. We'll have to ask him as to when it is possible. So kindly grant us a reasonable time. Okay. આ બધું થયું અને ultimately it percolated down to granting a video conferencing. કારણ કે it is like, it's like a matchmaking situation. મારે 5 વાર તો મળવું પડશે, મારે વર્ષ માટે મળવું પડશે. અરે પણ focus on the main thing. No, it was ultimately, after a lot of huff and puff, we got the video conferencing. Now, how did the video conferencing proceed? The video conferencing proceeded absolutely in a disastrous fashion. And that is the reason the SSC had to knock the doors of the High Court. Now, what the High Court took into consideration in the affidavit, in the petition, I don't know whether you are aware, you can call for a recording of the video conferencing. So in serious matters, please call for it. It will demonstrate as to whether the video conferencing has been taking place judiciously or not. It is not a mere formality. It is the judicial duty of the officer or the CIT concerned to take it a little seriously and to apply his judicial mind when the video conferencing is going on. So there has to be interaction. Now, હું આ એક પાનું છે, but kindly take it lightly. સાંભળવા જેવું છે. આખું નરેશન પિટિશનમાં of how minute to minute the video conferencing proceeded was given in the petition. The court called for the video recording and compared the video recording as well as the petition, okay, whether what is stated in the petition is right or not. For your benefit, પહેલી મિનિટથી from 000 minutes to 6 minutes and 43 seconds, blank video. 6 minutes and 44 seconds, we were there on screen. The SSE states. 7 minutes to 15 minutes and 18 seconds, learned advocate for the petitioner repeatedly asked whether he is audible. No answer from the other side. Complete monologue. 15 minutes and 19 seconds, we posted a message through the chat box. We have logged in. 18 minutes and 26 seconds, we posted a message through the chat box. We are waiting, sir. 21 minutes and 26 seconds, reply from the other side, received through chat box, meeting on. એટલે 21મી મિનિટે અને 26મી સેકન્ડે પહેલી વાર મીટિંગ ઓન છે ત્યારે ખબર પડી. 22 મિનિટ અને 11મી સેકન્ડે learned advocate for the petitioner asked that whether he should start his submission. બીજી જ સેકન્ડે કહે છે, reply from the chat box received, you are audible, please speak. 22 minutes and 32 seconds, hearing started. 23 minutes and 35 seconds, now this is very interesting. Learned advocate for the petitioner requested the other side to enable him to put submission on screen, which he is referring to. Permission from the other side is sought to upload submission. He informs the other side that he is in the process of uploading the submission. So આ કીધું કે ભાઈ મારે સબમિશન અપલોડ કરવું છે, મને પરમિશન આપો. 26 minutes and 2 seconds, the other side says in the chat box, yes. But no facility is provided, though through which one could share the submission on the screen. Further, no response from the other side to request of learned advocate except the word yes. પણ yes ને પછી આગળ શું, કેવી રીતે અપલોડ કરવાનું, ક્યાં અપલોડ કરવાનું, કોઈ વિન્ડો તો અનેબલ કરો જ્યાં હું અપલોડ કરી દઉં, નથિંગ. 26 minutes to 40 minutes, further 14 minutes, hearing continues where learned advocate for the petitioner makes his submission in his opening remark for 2 issues. 40th minute to 45th minute, audio was silent, though video was on, and Shri so and so was continuously speaking, and that too on the first issue only. બે ઇશ્યુ હતા, એક જ ઇશ્યુ પર હજી તો વાત ચાલી રહી હતી. No submission on second issue was allowed to be made. 45 minutes and 6 seconds, abruptly meeting ends. So the advocate is also not sure કે શું થયું, SSE is also not sure શું થયું, but એક ચીજ થઈ કે એડિશન થઈ ગયું. એટલે friends, this is how sometimes the thing proceeds, and you might be required to be very vigilant about the whole thing. Friends, as far as our lighter moment is concerned, સ્ક્રીનશોટ્સની વાત કરીએ તો હવે પ્રેઝન્ટ જેનરેશન, યંગ જેનરેશન છે, એના પર ફેસલેસ એસેસમેન્ટ જે આવ્યું અને આખો દિવસ એમાં ઇન્વોલ્વ હોય છે, એની શું અસર થઈ રહી છે. સો યંગ ચાર્ટર્ડ એકાઉન્ટન્ટ ઇઝ ચેટિંગ વિથ હિઝ અનધર યંગ ચાર્ટર્ડ એકાઉન્ટન્ટ ફ્રેન્ડ. So the first chartered accountant says, "Bhai, need your support. She is online." અને એવું કહે છે, "I love you. क्या करूं?" सेकेंड चार्टर्ड अकाउंटेंट, "भाई, सबसे पहले स्क्रीनशॉट ले ले. डॉक्यूमेंटेशन जरूरी है." So this is the impact of faceless assessment on the younger generation. I hope I was informative. I hope I was in a position to convey what I wanted to. Thank you so much.
Sir definitely cleared the point very well that giving examples enhances the understanding, be it any age. Thank you so much, sir, for the very informative session and for summing it up in a very hilarious way. We enjoyed it thoroughly. I would now request CA Parth Doshi, sir, to welcome Advocate Manish Shah, sir. Oh, I'm so sorry. At this instance, we would like to felicitate the committee members on the dais at the hands of our eminent speaker, Advocate Manish Shah, sir. May I please request you to present the memento to CA Maulik Patel, sir. Followed by CA Parth Doshi, sir. Advocate Rakesh Thakkar, sir. Advocate Narendra Karkar, sir. Advocate K.H. Katharia, sir. And C.A. Jigar Parikh, sir.
Proceed for lunch. Correct group photo. Next one changes, sir.
Thank you so much, sir. And with this, we come to the end of the second technical session, and I request all the dignitaries on the dais to please come forward for a group photograph. ISKCON, Eden Greens, Vyapar and Microvista Technologies. We would also like to thank and acknowledge the sincere efforts of various hardworking committee members of the various committees. I request everyone to move ahead for lunch, and we shall gather again sharp at 2:15 p.m. for the third technical session on benefits or prerequisites under section 20.